It's really a great pleasure to have Jeff Vogt here to talk about his new book. As we all know, the right to strike couldn't be more important. The strike tool is absolutely critical to the ability of working people to shape their lives and the politics in which they live. The right to strike is also a complete disaster in the United States under U.S. labor law. We just covered the strike right in labor law this week, and where we see that despite Congress's intention to protect the workers' ability to strike, the Supreme Court in 1938 created a right of permanent replacement workers, which has been a hindrance since then. So it's really great and exciting and gratifying to see this new book where Jeff lays out some thoughts and proposals for restoring the right to strike in the 21st century. So for those of you who don't know him, Jeff is the Rule of Law Director of the Solidarity Center and co-founder of the International Lawyers Assisting Workers, the ILAW network. In 2022, Jeff was appointed to the International Labor Organization, the ILO governing body, and the ILO Committee on Freedom of Association. From 2011 through 2016, he was the legal director of the International Trade Union Confederation, where he coordinated the organization's legal advocacy before the ILO, advised trade unions on labor law and policy, and supported their claims before national and international tribunals. Before that, Jeff served as the AFL-CIO Deputy Director of the International Department and as its Global Economic Specialist. He earned his JD from Cornell and his LLM from Cornell, and he is the editor and co-author now of two books. First, The Right to Strike in International Law, and what we're here to hear about today, The Right to Strike Reimagined. So please join me in welcoming Jeff.
You put my speaking notes with you. Yeah. No. Yeah. All right. Thank you very much, Ben and Sharon, and all those who were responsible for putting this together. I really appreciate it. This is the first stop on the worldwide book tour. So I just this book came out of work that we started with the first book around the question is the right to strike protected in international law? And this, I'll come back to this towards the end of the presentation. But there was the employers organized at the international level, at the International Labor Organization, took the position that although there was a consistent position on this for like 70 years, they no longer believe that the right to strike is protected. And then this, as we were writing the first book and thinking, all right, well, how do we argue for its protection under international law? We also thought, well, fine that we're protecting what we have, but even the ILO jurisprudence, which goes further by far than the United States and many other countries, there's still questions that haven't been brought to the ILO supervisory system that need to be answered. And I think limitations and compromises that were made along the way in the ILO supervisory system that set some roadblocks for the free exercise of the right to strike. And I'll get into that in a little bit. So I'm just going to do a kind of a walk through the highlights of the book for maybe like 20 minutes, and then I'll be happy to take any questions. This doesn't really focus on, it's meant to be, it's done by a group of about 20 lawyers, labor lawyers, some academic, some practitioners from around the world, and really wanted to come up with something that draws from the labor relations practices of multiple countries. So this doesn't really speak to any particular country, but rather kind of looks at the issues as they arise comparatively and also under international law. So So this book coming out now comes out at a good moment because 2026 marks the centenary of the UK general strike of 1926. A lot of major general strikes took place in the early 20th century here, Europe, and elsewhere. And in some cases, that was the last time we had strikes of that nature. And it showed the kind of the high point of industrial action now, like a century ago. And we look now at the ITC's Global Rights Index. They're the Trade Union Confederation for the world. And every year they put out a publication which kind of ranks and measures the exercise of freedom of association, including the right to strike and collective bargaining around the world. And they found in last year, 87% of countries had strike-related violations, either in law or in practice. So, on the one hand, we have this international protection, but in practice around the world, workers' rights to strike in practice is severely constrained and is being constrained with each passing day. So the book's simple argument and why we did this was really to look at the way the right to strike was conceived in the 20th century, which really grew out of the early 20th century industrial model of employee-employer relationships, this bilateral relationship between the two that was confined to one employer and had a number of procedural constraints. And now with the way that the workforce has evolved globally, within countries, between countries, that the laws that were molded around those structures don't make any sense. On top of that, you have many countries where the norm in industrialized economies was never the norm, and you have still extremely high levels of informality, people working out of any formal employment relationship. And in many cases, the labor laws in those countries replicate a lot of the structures of British, French, German labor law and kind of lock in rights for a very, very small minority of workers while leaving wholly unprotected the vast majority of the workforce. So we break this up into like three areas or three core problems. One is the question of status, who has a right to strike. Another is the question of objectives, what can you strike over. And then the third is means, like how do you go about exercising the right to strike. So, early on in the book, we start looking at the standard employment relationship model and the fact that, again, about 2 billion workers today are in the informal economy and therefore not covered by labor law, which in some cases, as you probably also know from US labor law, sometimes being outside the act gives you more freedom than being in it. So in some sense, those in the informal economy don't have the strictures, procedural strictures of being in labor law, but at the same time, it doesn't help much when the police are carrying you away for unlawful assembly. So chapter 3 of the book, who's done with a number of our colleagues, are looking at the question of casual self-employed and bogus self-employed, which we see now a lot with workers on digital labor platforms, food delivery or transportation, or all the other occupations now we're seeing being mediated through digital platforms. In the UK, the 0-hour contracts, the kind of permanently on-call contract workers, on-demand workers. And this misclassification is obviously meant to defeat the ability of workers to exercise whatever rights they may have under the national labor laws of that country. And although there have been some steps forward in the European Union, there's the EU Platform Workers Directive, which has a rebuttable presumption that you are in an employment relationship, but it has some important limitations, but quite important as a step. We also have those people who are genuinely self-employed, which, but still are in a relationship of subordination to those they're providing their labor to. And in a number of jurisdictions, we've seen how, including here, how courts have seen the efforts of those workers, whether they're musicians in Amsterdam or truck drivers in Korea or elsewhere, that they are seen to be operating in a legal cartel, right? It's the entry of competition law into the employment relationship. And then the question of informal workers, as I mentioned already, that have no contract, no employer to bargain against formally, and are often criminalized just for occupying public spaces. So, what in light of this? So, what do we do, right? So there have been the ILO has recognized that all workers, regardless of their employment status, right, have the right to exercise fundamental labor rights, including freedom of association, collective bargaining, and that includes the right to strike. But this is and not dependent at all on employment status. But this has not been a proposition that's been transposed into national law in most countries. Although I would say there are some jurisdictions like Italy, France, and others where you can strike on your own initiative over almost anything. So some have, and say the Nordic countries also have quite a broad right to strike. But so some of the suggestions that are put forward are obviously looking at the question of who is an employee in a very different light. Some have suggested the idea of this personal work relationship, which is to really cover everybody within the model of employment, except for those who are legitimately, self-employed and operating their own business with their own capital, taking risks, and seeking out clients, so that you can kind of draw a line that puts most people in the category of employee. In some cases, we've seen specific carve-outs to competition law. In Ireland, there's a case of voiceover actors who entered into a collective agreement with some radio stations that they were doing work for. They found it was a violation of competition law, and they changed the Irish Labour Act to make a carve-out for those workers. So then we have the question then of objectives to what can a strike be about. In many jurisdictions, they're going to confine strikes to a bilateral dispute with a single employer over standard conditions of employment. And what we've seen in a number of jurisdictions are saying that strikes which are purely political, or outside the scope of lawful collective action. In a number of countries, striking in support of workers employed by others is either prohibited or severely restricted, so the secondary or solidarity action. And there was a major case to come out of the European Court of Human Rights some years ago in the UK, finding that although there was a fundamental right to strike under the European Charter of Human Rights, that the UK's ban on secondary activity was within its margin of appreciation of fulfilling its right to strike, which is a curious outcome. But so it's and as if you're practicing in the United States, it's quite obviously the limitations. So we look at three areas. One is solidarity action along supply chains, and the fact that you have one entity, a corporation, who is benefiting from labor that takes place not only within its company, within its subsidiaries, but obviously along its business relationships along a supply chain. We look at how this is being treated in a number of countries as potential ways to address this issue, because cross-border collective action, even in Europe, has been stricken down. I think fundamentally the question is, and we find in again the Nordic countries, Sweden in particular, that they kind of leave collective action to the parties, and only will intervene if it really gets out of hand. So we have an interesting case of workers who are trying to organize Tesla in Sweden, and the other Tesla workers or others in the supply chain throughout, like Northern Europe, have gone on sympathy actions. And even within Sweden, like the one case came up where the postal, like you get your license plate for your cars through the Swedish Post. So the postal workers refuse to handle license plates for Tesla owners as a way to keep them off the road. And this was found to be a completely illegitimate use of the right to strike in Sweden. So there is this kind of model where you have the state saying basically, and as Congress said a long time, keep the injunctions off our backs. Like, we're going to stay out of this. If it gets violent, if it gets out of hand, if it goes on for too long, maybe we'll step in. But really, this is for the parties to sort out on their own. You can also imagine broadening concepts like joint employer to capture those who are making, benefiting or making decisions that affect workers throughout a supply chain, and therefore, it only makes sense to be able to have the right to strike against those who are actually making the consequential decisions that are affecting your working conditions, upstream on the supply chain, or broader kind of conceptions of like allied doctrines and secondary activity more generally. And we also take a look at how new forms of regulation like human rights due diligence, the European Union has recently passed its Corporate Sustainability Due Diligence Directive, which does assign companies based in Europe legal obligations for the rights of not only its own workers and workers in the subsidiaries, but also in supply chains. It doesn't speak directly to the right to strike, but it does recognize that there are legal obligations as to labor, including freedom of association, that flow all the way down the supply chain. And we can also look to some trade law, including the US-Mexico-Canada agreement, which has an explicit right to strike that is protected in disputes across the border. We also take a look at the question of political strikes and democratic action. We take the position, of course, that the right to, you cannot have a democracy without democracy at the workplace, and that wealth and income inequality are fundamentally corrosive to political democracy. As we can look around and see in the world that is certainly the case, giving rise to populism and authoritarianism worldwide. So there's a democratic kind of normative basis for asserting a right to strike and constricting those matters which are kind of deemed outside. The ILO is very kind of broad in saying you can have a right to strike for issues that are not necessarily related to the collective bargaining practice or the dispute. It can be over broader social and economic issues. But even there, they kind of draw lines as to what is political and not political. And I think we all recognize it can be a very blurry line. And I think one of our recommendations is that the ILO take a harder look, especially in the context of a democratic crisis worldwide, and also given the fact that trade unions, whether in Poland, South Africa, Belarus, South Korea, have been absolutely essential to the democratization of those countries, or efforts to democratize those countries. And then another one, and this was one of the chapters that I drafted, is to take a look at the issue of climate change and how that is addressed in the context of the right to strike. It's obviously a new issue in many jurisdictions, and we take a look at this in the context of collective bargaining over the right to strike, and whether you have a right to strike to try to compel your employer to bargain over those issues, or if you have bargained that issue, whether you have a right to strike to enforce it. We also look at the right to strike in the context of occupational safety and health, and the impacts of employer decisions that may have an immediate impact on the workplace. And there's under OSH law a right in most circumstances to remove yourself either individually or collectively from imminent harm. But I think we also need to question this temporality of harm. If your company you're working for is pumping lead into the air, and it may not be killing you now, but it will in 2 or 3 years from now, do you have to wait 3 years before you can strike over the issue, or is it the right to strike now because the harm is arising now, right? So this is an issue where the ILO has not really spoken about it, other than to say that in the context of climate change and the just transition, of course, the right to strike or the freedom of association and collective bargaining are key, but they are completely silent on the question of the right to strike. So we're encouraging unions to file claims with the ILO so we can start to develop that jurisprudence. And then finally, we take a look at the means, and here's where I think the ILO principles are the least helpful. And again, they're coming out of, the ILO is coming out of a social compromise from 1919, and out of a social democratic model of industrial compromise. So they have, in a number of cases, saying, well, yes, you can legitimately have a notice requirement before you can strike. It just can't be too long. You can have certain balloting requirements, but they can't be excessive. You can have mandatory conciliation mediation before going on strike, and enforceable peace obligations as well that can prevent workers from taking not only strike in their own workplace, but solidarity strikes as well. So we in the UK. Under the previous government, had introduced a number of really regressive balloting requirements that made it really nearly impossible to strike. And this chapter, done by Tom Yanovitz, who is a professor at the University of Bristol, really kind of looks at the British experience. And then finally, we take a look at the ILO overall, and first take a look at the dispute over whether the right to strike exists as a question of international law, which goes back to the first book. And this is a matter that's now actually before the International Court of Justice. As you know, UN bodies can send disputes over the interpretation of their instruments to the ICJ for an advisory opinion. Once in 2012, the employers took the position that they were withdrawing the recognition of the right to strike. It took us another 13 years to convince enough governments to send this to the ICJ for an advisory opinion. And we are literally expecting it any day now. So we can come back and talk about that. I think it'd be a very consequential decision. I feel very good about the fact that we're going to win this. But it will mean a lot, not only for the right to strike, but for the ILO supervisory system as a whole, which is under severe attack by the employer community. I think recognizing that the government's support for the ILO is on the wane. The U.S. is in severe arrears to the ILO. Others are too, and I think there's just a less enthusiasm than there was in the past for resolving disputes at the ILO or regulating at the ILO. So I think it will be interesting to see how this decision then either solidifies the normal value of the ILO's instruments and their supervisory system, or whether this provokes the employers to further the attacks on the system, or both. But we shall soon see. And yeah, maybe spend 25 minutes, so maybe I'll stop there. And happy to take any questions.
Questions? Yeah.
Hi, thank you so much for this. It's very interesting, and I'm very excited for this book. And my question is on, I think one of the chapters you mentioned, you talk about this book is focused about like right to strike in supply chains. And I do think it is really interesting approach because you mentioned there's new forms of regulations like HRDD, like trade plus agreements. These are actually like I think like in my perspective, mostly these approaches are actually used as something that alternates like right to strike in many narratives. So like I work mostly in business and human rights part as a labor rights lawyer. I have a labor rights law scholar, and it's very frustrating to see that, okay, instead of having unionization, let's just use an HRDD. So the corporations can just do the due diligence, or instead of unionization, maybe you can just use a dispute mechanism on the trade agreements. And yeah, we don't actually really need the work of a union, but it's a really interesting approach that actually this HRDD and trade union agreements can actually boost up the right to strike. And also, I do see a lot of this new narrative that climate and just transition rhetoric should be kind of prioritized over the workers' right because it's better for the earth, kind of like narrative. So I really love this approach, and in that sense, I really love to hear more about like any case studies or the examples that mentioned in this book to, provide more strong argument for this. Just love to hear more.
Thanks. I say on the HRDD issue, I think it's. I also have my skepticism about HRDD, and I wrote a paper last year looking at the CLJE before it was amended by the Omnibus Law and had a kind of labor rights analysis of it. And kind of took a look at, from when the UN Guiding Principles were established to when CLJE kind of the process started. And if you assume that, even though it wasn't required at that point, except maybe in France in 2017, that if companies were starting to incorporate these expectations and responsibilities, that this would be reflected in data, at least marginally, but we found that globally, union density and collective bargaining rates fell at the same time that companies were supposed to have this obligation or responsibility around freedom of association and collective bargaining. So whether HRDD is now that it's law in Europe, is going to change that, I don't know, or could be seen as a substitute. On climate, I think it's most limited in countries which kind of follow the British system or its progeny, including the United States. Here, the biggest issue we have is around what's a mandatory or non-mandatory subject to bargaining, and whether occupational safety and health may be could be on the mandatory side, but other climate-related issues may be on the permissive side. And obviously, taking any collective action over permissive subjects of bargaining are going to land you in a lot of trouble. So, but we have, again, citing my favorite countries like Italy and France, there's almost no limitation on strikes of that nature. So it is a really mixed picture. Some countries allow, like I said, strikes to get something onto the bargaining table. Some don't. Some countries allow the strike to enforce collective agreements, including negotiating climate-related issues. Others don't. This question on the kind of the OSH framework, and to the extent to which, outside of collective withdrawal in the face of imminent harm, how far away from imminence is a strike possible, or if, for example, a company is engaging in activity which may violate the environmental laws of the country, is that enough of a basis, right? So there's a very broad picture on that comparatively. Yeah, over here, there, and then there.
Thank you for this. When I think about sort of optimistically or hypothetically the right to strike being reimagined, or the strike more generally being reimagined and reinvigorated, I think in particular in the areas where strike shades into protest, and that I think very American. I don't really have a great international context, but I think in the American context, we're at a point obviously of relatively low union density, perhaps somewhat relatively high strike occurrence for that union density, but certainly a protest occurrence, I feel like, is low union and strike occurrence density out of the water. I think in particular about the protest or strike activity that can be either can be or has been characterized as political or generating kind of this general strike term. And I wonder to what extent you think that there are potentials for reinvigorating and reimagining the right to reinvigorating the strike as a tactic and reimagining the right to strike as kind of legal matter in that habit. And that is takes a very kind of extra statutory approach to how it happens, how people participate.
Yeah, I think and others here know U.S. labor law far better than I do, the weird development of the First Amendment, basically, if you're in your union, you can do it. If you're not in your union, you can do it. But again, looking at it more comparatively, I mean, there's a much wider latitude for protest action by unions, whether it's over public policy or legal reform or it's May Day or whatever it is, which just has not been the practice here in a long time. And I think it also goes to the point I was making earlier that sometimes, as here too, being outside the labor law can, in some sense, be more liberating, but also at the same time more precarious, because then you don't have any legal protection necessarily, but you also don't have the strictures, the procedural strictures on you either. So, in some sense, when we talk about formalizing the informal economy, that's good in the abstract, but in some senses, bringing people into formal employment relationships and under current labor laws may be actually a worse bargain than being on the outside of it. Again, depending on the country and the laws.
Hi, thank you so much for this presentation. I'm really looking forward to reading the book as well, and this is really, really helpful. I have, guess two questions. The first was one that I initially had, and then the second one is kind of joining the comments that you were responding to the first question. So something I've been thinking a lot about, and I think that your work really illuminates this, is that there is a problem of jurisdictional arbitrage that emerges when employers or firms are faced with a menu of options where there are stricter labor laws and enforcement. So the one way to address that is through international cooperation, such as the ILO, and that has had successes and also currently is at a moment of weakness, given the strategic alliances at place in the country. But another possibility, which I think your work also highlights, is this idea of like an anchoring jurisdiction that exports its rules and laws abroad. So we're thinking about the EU, for example, and the Brussels effect. And so I was curious as to what you've seen so far in your work as to how HRDD, CSJE, or these like European Union laws, have they functioned as jurisdictional anchors in ways that then create more robust supply chains? Or have you started to see firms shifting their operations away when there is an anchoring jurisdiction, even though that's a market that they really do need to enter? So that's the first question. And the second question, sorry, it's on a different note though, because even though my first question was about CSJE, I wonder if one of the challenges with the model of the EU model, even though I just asked about its positives, is that it really embraces like a corporate law disclosure model, which is what Minju's question was also getting at. So it's not really about enhancing the power of workers in the supply chain. It really takes what's more of a corporate due diligence model about disclosure-based, kind of like the ESG model, and then exports that outwards. So I'm wondering if that might also be mixed in with some of the inefficacy, despite the potential of the first prong of kind of like action. So I'd love to hear more like your thoughts on that.
Okay.
Thank you.
So maybe grab a couple more questions I saw, and then I can try to do a group. Yes.
Sorry, first of all, I'm sick, so I'm hoping that my voice isn't too rough to hear, but I wanted to say thank you as well for your time, and I thought that it was a really fascinating conversation. My background personally is in international law, and I'm a first-year student here, but I was curious to hear more of your thoughts on what you mentioned for climate change and the temporality behind that.
Sure.
Specifically, what came to mind was thinking about focusing on the global south or nations that are relatively trying to develop, and how when we're thinking about climate change's impacts being something that's more spread, how nations struggle to tip that balance scale towards developing economically versus trying to incorporate labor laws that would be proactive in nature.
Right.
And more specifically, I'm curious if you're optimistic about that and whether you've seen any.
All right. Great. Maybe one. Sorry, we'll take both. Oh wait, there are three. So 1, 2, 3. Please.
Hi. My name is Alexandra. I'm an AI scholar, but I'm also now working on the future of work with AI. Or, other trajectories are possible too. So, future of work with AI instead of humans, so many different possibilities, not all of them beneficial. But my question to you is to what extent you consider AI to be a future very important source of strikes, and rebellions of different kinds. Do you consider that already now being like a very important topic? And what are your thoughts on how it's going to progress? We saw the strike at Hollywood. Obviously, it was a very big one, and I think a fairly successful one. Not many others were successful, but there are also not that many others appearing, which is interesting in the context of the fact that you clearly already see the impact on the job market. It's not too positive. Entry-level jobs, we can talk about many different areas where AI is already hitting quite hard. And yeah, I was wondering if this is something you also think about.
Sure. Here,
Yeah, so I just, maybe this is for another time, but your anecdote about Tesla in Sweden was fascinating. I assume it was the Postal Workers Union in Sweden that took this initiative at the risk of the ire of their bosses. And anything more you get out about that anecdote would be great.
Sure. I can point you to the chapter where it's discussed.
Oh, okay.
But,
I'm just wondering, what was the name of the case in Ireland about the I'm Irish about the voice over actors, and was this at the EU? Was this at the EU level or ECHR?
Yeah, sure. And I should also mention that the book is open access, so free to download. So. Of course, you want to buy it, but it's free. So on the CSEE, I would say I'm kind of a CSEE skeptic because exactly as you said, I think it still puts corporations in the driver's seat for the most part. As you know, and I've seen this, in so many times before. Like, company will come up with a due diligence plan, and they're supposed to identify salient risks. And I think under the CSEE, it's supposed to be like serious risks that they're supposed to identify and assess. So the question is whether freedom of association and collective bargaining is ever going to be considered a serious risk, especially when you look at the kind of the recitals before, and what they identify as serious as being like, death, imprisonment, these sorts of things that fundamental labor rights may not fit in there. And then you also see, like, as one example, engaging with a telecom company, multinational telecom company, who had a subsidiary in Colombia. Their due diligence plan was focused in on forced labor and child labor, right? Because I guess these are serious risks. Knowing that Colombia, at the time, was one of the kind of worst countries for freedom of association, but it was nowhere in their due diligence plan, right? So I do worry that we're going to continue to see companies picking and choosing which risks they really want to address, where freedom of association and collective bargaining are universally at risk. The law also, I think, allows companies to outsource a lot of their assessments and mitigation to auditors and MSIs and stuff. So in some sense, maybe replicating parts of the same model that we're trying to get away from. So I think what was interesting, I think, from the, that the authors of that chapter were getting at is that this is kind of more of a recognition that, not of the CSEE per se, but the recognition, legal recognition that there are rights and obligations that are multi-jurisdictional. And this is actually, I just came back from the ILO governing body, and we were trying unsuccessfully this time to get the ILO to put on a standard setting track a new convention that would be on responsible business conduct and would kind of get outside of the kind of jurisdictional silos that we do see in the ILO and facilitate both cooperation between countries, but also requiring regulation of the extraterritorial conduct. And also, I think what would be also important is facilitating cross-border collective bargaining, which would also be tremendously helpful. But the employers group in a number of countries were flat against it. The EU was helpful, but wasn't enough in the governing body to move the agenda. On voiceover actors, this actually is an interesting case because it came out in the context of the financial crisis of 2008. And so the collective bargaining agreement, the Irish government initially actually wanted to, at the time, carve out do a carve out to the the name of the act, the Labor Act, to cover this. But there had been an agreement with the Troika at the time that they couldn't change the competition laws at all, right? Unless the IMF, World Bank, and the European Central Bank agreed. So it was only after they got out from under the memo with the Troika that they were able to make that amendment to the labor laws to carve out that.
And it was domestic case?
Yeah. We did bring it to the ILO, and the ILO was like, you need to fix this. On AI and the future of work, I think there are obviously the SAG-AFTRA strike. I haven't seen yet a real upswell of strike action over AI globally, though it is rapidly rising up on the kind of the urgency of action to take, whether it's legislative or through collective bargaining. What I am seeing more of is just the broader kind of digital landscape and workers who are part of digital supply chains, trying to take collective action in the face of, for example, there's a pretty famous case, but Meta had outsourced all their content moderation. So when you go to Facebook, you don't see obscene imagery or violent imagery because somebody who was hired through an outsourcing agency in Kenya was 8 to 10 hours a day looking at all that material, tagging it, and taking it down. Right. So it was then them trying to form a union, taking collective action at the workplace, where we see kind of the upswell of resistance to the digital economy. Also, obviously, see it on those workers who are on digital platform apps, Deliveroo, Ubers. There's strike activity around the world on that. Whether it's their employees or not employees, has been one of the interesting areas where people have just taken action regardless of its legality. I think on climate change, it's a really mixed picture depending on where you are in the political situation at the time. I'd say there is important work that's being done, like in South Africa. COSATU is engaged in with the president on a just transition task force, and there's kind of regular dialogue between unions and the government. Probably needs to be more, and I don't know to what extent the dialogue is leading to policy action that is benefiting, moving in the direction of the unions, but they're at the table, which is more than you could say in most countries, where unions are totally sidelined in this question. There is a lot of collective action I think that is out there, but it's not necessarily being recorded. One, because it's not necessarily done by unions; it's being done by farm workers who are burning in this 110-degree heat and decide they can't take it anymore, or there are people in the informal economy without water, solar protection. So I think that it's out there. What I think is also interesting is you're seeing more kind of blue-green collaboration, protests and strikes together, kind of forming a broad front to move the discussion forward. But I think as a regulatory matter, as a labor law matter, the climate is still very far from being integrated into labor law. And I think so there's a whole kind of emerging field of kind of just transition law looking at the intersection of the two. And how does environmental law inform labor law? How can labor law inform environmental law? And where do the two kind of come together in its own organic law? So something to look out for, something I'm very interested in, but it's still, I think, in its infancy. And Tesla, it's in the book. I know that Tesla then sued the Postal Workers Union. They did? They did. I think the case was tossed from what I remember, though. Nobody in Sweden likes Elon Musk, so it wasn't a hard choice, I think. Are there other questions? Yeah, please. Over here.
I think following on the previous question about the sort of tipping points between formalized a world where we are pushing toward more formalized structures for unions to emerge, and one where, which I think is closer to what we have now, is like more and more people moving into informal economy roles, whether we call them jobs or not, I think that's up for discussion. And doing kind of things out of necessity, like you were saying, like farm workers protesting their lived conditions. What is like the normative goal for the world of like people that create law and policy if, you know, there's a conceit there that law is not working?
Yeah.
And so, you know, right now I'm studying like the 2 state laws in the United States that emerged to help unionize rideshare drivers. And I think I get that the theory is the protections of the right, like an explicit right to strike, and other things are net positive. And, you know, there's just a striking similarity in the text of the laws between the current NLRA we have and now that we've already kind of like thoroughly problematized. And so, like, what do you feel like people should be, what are the conversations that need to be had about where we should be headed, where we should be aiming to help people, help workers in real life?
Yeah. It's a whole class. Yeah, I mean, there's a huge debate within the community who's working on informality and informal work and how that intersects with the union movement and what are we actually trying to accomplish. Again, given the limitations in many cases of labor and employment law. I think there's a recognition, like, the ideal is not just moving people in from, you know, unregulation into bad regulation, right? So I think there's some experimentation that's happening, whether it's like you know, municipal regulation for street vendors that address kind of what are the big issues they have, like access to use of property without being evicted, right? It is in some cases being registered in a social security system. It is you know, any number of perhaps minimum wage coverage. So sometimes it's done at a kind of very local level. You're seeing kind of national legislation around domestic workers, which again is looking at, sometimes it's done by throwing them into the general labor law of the country. Some it's kind of coming up with bespoke regulation that recognizes differences of nominally, you know, self-employed. I mean, there's a relationship of employment, but you know, it may be that you have multiple clients. You're not just in a single employment relationship. You know, recognizing that there needs to be flexibility, but not flexibility that denies protection. Flexibility that enhances protection. And we're having this fight right now around the platform work, where in June of this year will be the second year of the ILO, where we're trying to negotiate a new convention and recommendation on digital platform work, which is not going tremendously well at this point. But it is, you know, one of the big issues that we're dealing with a number of governments is, okay, yes, we agree that regardless of your employment status, you should have these fundamental rights, but who's responsible? Is it, you know, is it the restaurant from where you're taking the food and bringing it to someone else? Is it the Deliveroo, which maybe you have a subsidiary in that country? Maybe, I think they're based in the Netherlands. Who ultimately has responsibility immediately? And, you know, then what are the specific ways that you exercise your rights differently in the digital space? Well, in this hybrid digital real space that is different. And, like you can imagine a digital strike by everybody just going off the app. Right, that is a collective withdrawal of labor. It's not like a traditional strike, but it's so yeah. And what is that kind of activity protected? So there's just like a lot of things you begin to think about. So I don't know if this is. I didn't give you any kind of answer. I'm just more problems, but yeah, people are aware of it, and we're all struggling to figure out how to. And I think with the right to strike, it's recognizing that it is like the one tool that workers have to withdraw their labor that gives them any hope in the workplace or broader society or any sort of kind of liberation, right? We've so boxed it in with either regulation or jurisprudence that it's kind of lost that liberatory potential. And so how do we unpack it from that and give it its impact again, especially in a climate now where, you have, I can't remember exact numbers, but like 100 people who have the combined wealth of the bottom 50% of the world, and maybe even fewer people, right? So in the face of that, like we need these tools. Yeah. So I think, yeah, of course. I think I covered all the questions.
Yeah.
Oh yeah, you have one.
Hi, thank you. Perhaps as like a follow-up to the Swedish postal workers who are presumably public sector employees, could you talk a little bit more about internationally how the distinction between public sector and private sector employees are treated in this?
Yeah, internationally, like so, the ILO draws a distinction between civil servants and the public sector, right? So, like, their term of art is if you're exercising authority in the name of the state in some capacity, you can be denied the right to strike, or it could be restricted. But if you're a teacher, a public sanitation worker, a public bus driver, any other public service, then you have a right to strike. Where limitations could come in is if it's deemed like an essential public service, so which could be like hospitals or, it depends country to country on the circumstances, but you could, so if it is deemed essential, electricity maybe, the country could say, well, you can strike, but we have to have at least 25% of the workforce stay on, so we can at least maintain operations while the rest of you are out striking. Some can outright ban it. You have to have compensatory measures if they do ban it outright, which would be like interest arbitration, right? As a compensation for not having the right to strike.
You started off talking about the 100th anniversary of the British General Strike of 1926, which a lot of historians say wasn't really very successful. Partly the early BBC, supposedly neutral, took the government side, made things very difficult. But I wanted to ask going forward about general strikes. In 2024, we heard a lot from Sean Fain of the UAW that he wanted the labor movement to gear up for May Day 2028 as a time for a general strike. There was initially a lot of excitement. I suppose the Trump wave has depressed people a bit. But, I thought, I'd like to hear maybe your reflections on the future of the general strikes that have been kind of, interjected. I know the United States, we had the Seattle general strike of 1919. That was a really big one. But I know Canada, Elaine Bernard pointed this out in labor history, that the Canadian general strikes at the same time actually accomplished a lot more for the long term. The Seattle general strike was, not as many long-term victories. But I'm wondering, your thoughts about, this idea that in 2028, some people talk about that the labor movement should get this idea together.
I mean, I don't know what you consider some call the kind of Minneapolis uprising of a few months ago a general strike, potentially. It was effective. Should give a signal to others about the potential for strike action that also combines with protest, involves community, and is broader than the union membership itself. All I can say is it's a matter of international law. Like, it's not and I've been in general strikes myself in Belgium, but it is not like an unusual thing for all the union confederations in the country to just say on X day we're all going out. As a member of the Belgian Socialist Union, FGTB, and we all went out with, horns and balloons and all that kind of stuff, and we're in the Grand Place.
I didn't
So, like, as an international matter, it's not. It's not controversial. But yeah, certainly here, there's not the legal framework for it, so you're running a huge risk. But I guess the question is, and it goes to the old adage, there's no such thing as an illegal strike, only failed ones, right? So, if you get enough people out, it doesn't matter. And this was the case, with the teacher strikes in a number of states that took place some years ago, where it was unlawful in, I think, West Virginia and Oklahoma or wherever they were. But they were successful because they had wall-to-wall people out. Yeah, bus drivers were respecting the strike. You had, the broader education sector got behind it, and it worked. So, yes to general strikes.
Yeah, I think we're ready to wrap up. So thanks everybody for coming in. Thanks, Jeff, for an incredible.
Yeah. Thank you very much.